Welcome. Today we are talking about estate and legacy planning, how to keep your family out of court and conflict. We have an action-packed webinar today, and I want to make sure that you can hear and see me okay. So please drop a line in the chat box just letting me know that you can hear me and that you can see the slides. Okay, great. And the best way to get the most of our time together today is to turn off your phone, close your door, close any of the background applications going on your computer. This will be worth your time more if you turn off those distractions. You really do deserve this time for yourself and ultimately for your family. And I want you to know that your time is very well spent today. So if you stick around to the end, we are going to be offering a bonus, a golden ticket, and that is going to be worth $1,000 in estate planning services. So please make sure that you stick around and you'll get more information on that. And I'd like to know a little bit about you today before we get started and get a sense of where you're at and what you're thinking with estate planning. So if you'll type into the chat box, I'm curious, do you currently have an estate plan in place? And this includes any estate planning documents whatsoever. So a simple yes or no is fine. Okay, I see a few no's and a yes, so mostly no's. And if you don't have an estate plan, and most everyone here today doesn't, you're in line with the statistics that right at 62% of adults, they don't have estate planning documents in place whatsoever. And if you're talking about only the adults with minor kids, that percentage of adults without an estate plan is even higher. So let me know if that describes you. Why would you say you don't have one? So just type in what comes to mind if you don't have a plan. So okay, so I've never gotten around to it, but I know I should. I didn't think about it until I became a parent, and I just thought about it when my mom passed away. So that's very common, and not sure, but I know I need one. And so these are all valid reasons that we are going to talk about today. And if you have an estate plan, what do you hope to learn today? And let me know what comes to mind. Okay, see, I think there are gaps in my plan, but I don't know where. I did my plan a long time ago and I haven't kept in touch with the guardians named in the plan, and I did my will on Rocket Lawyer, but I know that's not enough. So if you do have an estate plan but don't know whether it's complete, or if you don't have an estate plan at all, or maybe you have an isolated document here or there, all of your responses have touched on some of the biggest fears I've run across in doing estate planning with many, many families. And first of all, we understand that there is this fear that planning for it will somehow hasten its occurrence. And that's one reason that we have heard, but I have good news. Honestly, I've never seen a correlation between helping a family complete their plan and then something unexpected happening right after. And I actually want you to know that you are in the right place today if you've had you've had those fears or really any other fears around estate planning that I'm going to talk about in a second, that you have something or someone that you care about in your life that you want to protect. And it really doesn't matter if that something is big or small, expensive or not. You're in the right place. And if you've done a fill in the blank will, but you're not sure if it'll work, so maybe you're not positive a document you created online will fully protect you and your family, or maybe you're wondering whether or not it will protect your family, and really what is the risk of a do-it-yourself estate planning anyway. So if you've ever had any of these thoughts, you are in the right place. And the big one, you are nervous about how much will cost, plus where to start and how long the process will take. It does seem like such a big undertaking, and I absolutely hear you in that, so we're going to go over that today as well. Honestly, at the end of the day, when we talk about estate planning, the reality is that estate planning is not about you. It's about the people you love most. Your loved ones will know if your plan is working or not when the time comes. And sadly, we've heard from so many of our clients when a loved one passes away, but my mom or my dad told me that they took care of this. I don't understand why we're now in court, or why we're in conflict, or why we have to jump through these hoops or take these extra steps to get our money. And so this is part of what we help families do. Truly take care of it, leaving no stone unturned, and making sure loved ones aren't confused or caught off guard later. Well, first, I want to talk about what you'll learn today. And listen, things happen, they do. And you already know that, and you didn't need to hear that from me. But the real question is, what happens next? That's what we're really going to focus on today. And we're going to explore this from two perspectives, the before perspective and the after perspective. The before perspective is what happens if you have no estate plan or only a document here or there when a sad day occurs. And it will occur. There's no doubt about it. Your family is left vulnerable. What will they have to go through? And for each sad day that we're going to go through today, we're going to talk about the before perspective. And another way of thinking about this is the state of California's plan, or sometimes it's called the do nothing plan. And you'll learn that what the state has decided is probably not what you would decide. And then we're going to look at the after perspective, and that is how a potentially tragic situation can be turned into the best possible scenario for you and your loved ones, keeping your family out of court and conflicts. And as you might guess, this comes down to communication and things being in writing, clear and comprehensive. Then we're also going to learn how to start the estate planning process, how long it will take, and how much it costs. And don't forget the bonus golden ticket at the end. Before we delve into all that, I want to give you a little bit of background about who I am and why I devote myself to this. This is really my intention, my why around my approach to estate planning. And my story centers around, being a parent. I don't know if you guys can identify, but really a turning point in your life, that aha moment. And I started contemplating whether my litigation career was the right fit for me and if it was serving my family. And ultimately, I decided it wasn't. And let's see, because growing up, when people would say, what do you want to do when you grow up? I would say that I wanted to help people. And when I went to law school, and people say, well, what kind of lawyer do you want to be? I said, oh, well, I'm not going to practice law. And that's because at that time, I had this negative perception of lawyers as, a career that really just churned out documents in exchange for billable hours. And that didn't sit right for me, that I really didn't feel like I was helping people in a way that I wanted to with that kind of law practice. For me, it was really about, did I feel like I was fulfilling my true purpose? And not that, I wasn't helping people. It just didn't feel that way in the adversarial environment. And honestly, I didn't like the hourly billing model either, which really doesn't encourage client communications. So I was at this turning point, and I knew I wanted to do something that felt closer to truly helping people, not just going to court. And I'd had the opportunity leading up to this time as an attorney to do some estate planning. And when I could do that, I truly felt like I was serving and helping people. And so much about estate planning is the opposite of what you think about in the law, what you think about in litigation. We don't go to court. We don't have to worry about opposing counsel. It's simply all about what you want for your family. And a lot of times it's some sort of life-changing event that's prompting families to come in at all. And it's about helping them get to where they want to be legally. And we don't have to go to court to do that. And as we'll learn towards the end today, estate planning lends itself to a flat fee model, which really helps with the attorney-client communication and encourages relationships with our client. So these are my children here. This is my family, and family is so important to me. And I'll admit, even for me, I didn't have estate planning until after, my first was born. So I hope you can identify a little bit with my story in the sense that if you're confronting some sort of life change or internal nudge, and you have to do something, you need to have something in place like an estate plan, then you come to the right place. You've started the ball rolling, and it's often that estate planning comes up at these times of transition. And a little bit more about me. I went to USF School of Law. I went to UC San Diego undergrad. I'm the director of 2 local nonprofits, and I've also been featured on a few podcast series under Mama Bear Podcast. And as we get started here, I want you to stop and ask yourself, and you can type this in the chat box or just, jot it down in your own notes. Who is it in your life that needs protection? For me, it's my family. It's my beautiful children that need protection. If you suddenly could not be here for them, who are these loved ones who need your protection? By name, you can jot it down like I was saying, and we're going to come back to that shortly. But for now, let's jump into learning about estate planning by getting to know the Bliss family very well. They are going to experience a few sad days today, and we are going to learn by exploring what happens when each sad day occurs. You'll likely have questions as we go, so make sure you jot them down. At the end, I'm going to share my email address and a way to schedule a 15-minute call so I can answer those questions for you. So this is a beautiful family. We've got Mark, Molly, Alexander, Benjamin, and Caroline. Mark and Molly are happily married. They own their lovely home here in the Bay Area, and they have 2 wonderful children, Benjamin, who's 12, and Caroline, who is 10. Molly also has a child from a previous marriage, Alexander. They have joint accounts. They are putting away money for retirement. They both have life insurance to make sure there's financial resources there if one of them were to pass. And they both came into the marriage with a little bit of savings already. They each have a solely owned investment account, and Molly's solo account in particular, she also has an inheritance from her parents who have passed away. But they've never had to touch that money, so Molly's inheritance is still sitting there in that account. As I mentioned, Molly was married prior to marrying Mark. She was married to her college sweetheart, Xavier, and Xavier and Molly had a son, Alexander, who's now 15. Xavier was kind of the wild, crazy, fun guy in college, but he never settled down or got serious as a husband or father, so it didn't last. As a result of the divorce, Molly has primary custody of Alexander, who lives with his half-siblings, Benjamin and Caroline, and stepdad, Mark. And also as a result of the divorce, Xavier updated his life insurance policy. He obviously doesn't want his $1 million policy payable to Molly, his now ex-wife. He wants it payable directly to his one child, Alexander. So Xavier made the update on his life insurance. And honestly, the fact that he had life insurance at all is the one responsible thing Xavier did during his mostly party-filled life. Just your everyday family, really? Well, but this poor family is going to have to go through the ringer because they're going to have to go through quite a few sad days in a really short period of time for us to learn together today. So I hope you'll bear with me because the ill-fated Bliss family is going to be put through just an absolute train wreck today. As a side note, I hope you can get a sense of how I approach this topic of life and death. I don't take myself too seriously. I enjoy humor, but at the same time, I want to make sure I'm conveying these really important points and teaching and educating you as part of the process. Okay, so a sad day. With this said, we're going to jump into sad day number 1. On sad day number 1, Xavier's turning 40. This is his big birthday. He wants to do something he's never done before, so he's decided to go skydiving. On his 40th birthday, he steps out of the plane to go skydiving, but he is just so beside himself with excitement that he doesn't pay attention to the safety instructions, and before you know it, he's jumping out of the airplane before they even finish getting him ready with the parachute and backpack. All of a sudden, it's a skydiving gone bad scenario. Adios, Xavier. But Xavier has no estate plan. Although remember, he did do one responsible thing in his lifetime. He had life insurance. And he named Alexander as the beneficiary. A good plan, right? Well, Xavier thought he had a plan, so to speak, by having life insurance. But what's about to unfold is anything but a thoughtful and decent plan that leaves Alexander better off. Alexander is going to be worse off. Alexander's only 15. He's a minor, so Alexander is pretty pumped. He's a teenage millionaire, and he's really excited about the very fancy red car he's about to buy. In the meantime, Molly, as you might imagine, is getting nervous. She's thinking to herself, wait a minute, Alexander's only 15. $1 million is a lot of money. Can he be in charge of his own money at 15? How can I help make sure he's responsible with the money? He's still a teenager and needs to learn some financial lessons and responsibility. Molly calls our office and lets us know what's going on. And we deliver the bad news to Molly that we have to go to probate court to figure out who is going to be in charge of that $1 million until Alexander is an adult, meaning 18 years of age. Probate court is required because Alexander is a minor and minors can't be in charge of their own money, whether they're 6 or 16 years old. Not until they're at least 18 or in some cases 21. So a judge must figure out who is in charge of the money in the meantime. Well, Molly wants it to be her, of course. As part of the process, we have to submit Molly's credit report and background check to the judge, which she considers invasive, but she honestly has no choice. The judge, a stranger, wants to see these things to make sure that she is a seemingly responsible person. By the way, everything about this court proceeding is public, and it's a record that can be searched by anyone, and it takes time. We are now on the court's timetable. And guess who else shows up in probate court? Zachary. This is Xavier's brother. Now we're talking about Xavier's life insurance money. I doubt Xavier would want Molly, his ex-spouse, managing it. It seems like he'd rather have his brother, Zachary, manage it for Alexander. So I have a question for you. Who will the judge choose as Alexander's financial conservator? Molly, Alexander's mom, or Zachary, Alexander's uncle? The financial conservator will manage the money for Alexander until he's 18. So who do you think? You can type it into the chat box. Who will be appointed as Alexander's conservator? Is it Molly because she's Alexander's mom, or Zachary because he was related to Xavier, where the proceeds came from? Okay, I see Molly, Zachary, Molly. Okay, so overwhelming vote for Molly. Here's the answer: we don't know. There's no legal requirement that the conservator be the surviving parent, and there's no legal requirement that the conservator be a blood relative of the deceased person from whom the money comes. The judge has no clue who is actually a responsible adult because it's not their money. It's Alexander's money, and the judge needs to make sure the conservator is going to be responsible with it because he or she will have access to the money, but they're only supposed to use it for Alexander, not vacations or fancy boats. And Molly is shocked because she knows she would never do that. She thought this is going to be easy and that she'll just be the default conservator because she's Alexander's mom, but there is no default. And whoever the judge appoints will serve until Alexander's 18 because then he is an adult. So all of a sudden you have an 18-year-old, because when he turns 18, he's going to receive the money. So all of a sudden we have an 18-year-old in charge of a lot of money. There is no oversight, no financial understanding required, no requirement to check in with anybody. He can do whatever he wants with it at that time. So imagine what he'll spend that money on when he turns 18. So let's do something better for the Bliss family. Remember, Xavier thought he had a plan because he had a life insurance and because he had a son, named his son as the primary beneficiary. He did not know or realize what all would be entailed if Alexander was a minor and that he was throwing his son into the court system. So let's fix these issues. So idea number one. Alexander decides instead to leave the money directly to his responsible brother, Zachary. He thinks this is an easy, quick fix. Lesson learned, don't name a minor as a beneficiary, but this is a huge takeaway. Never do this. You don't ever want to name anyone as a beneficiary who you wouldn't want to truly receive the money without any restrictions attached. Xavier doesn't really want Zachary to receive the money. He actually wants Alexander to. He's just thinking he can get around probate easily. But this is a bad idea, and here's why. If Zachary is the beneficiary, it's Zachary's money. It's as simple as that. If Zachary wants to use the money for Alexander, great. If Zachary wants to use the money for himself, great. He gets to decide it is his money. And because it's Zachary's money, if Zachary goes through anything in his life where he might owe someone else the money, maybe he owes money to someone who sues him, a creditor, an ex-spouse, that because Zachary has ownership of all the money, someone else who's Alexander doesn't even know can garnish the money directly from Zachary, leaving nothing for Alexander. Then Alexander is completely out of luck. None of these people had anything to do with Alexander or Xavier or what Xavier wanted for Alexander, so that doesn't seem fair at all. So idea number two, Xavier signs a simple will that says, I leave everything to Alexander. If he's under 21, I put Zachary in charge. Everyone has probably heard that you need a will. So this sounds like it would be a good plan. And not only is he saying everything goes to Alexander, but also that if Alexander is not 18, but even under 21, then Zachary is in charge of managing the money for Alexander in the meantime. But there is a hole in this plan that I think will surprise you. Xavier did not know that at the end of the day, two simple things override your will. This is joint ownership and beneficiary designations. These override your will. I'll give you a fair warning. The next slide we're going to go through has the most words out of all the slides, but there is a good reason, I promise. Let's talk about these 3 buckets. We've got joint ownership, beneficiary designations, and your will. Here's the thing. When someone calls me after a loved one has passed away, the first thing I want to know is not whether they have a will. I first want to know whether they have jointly owned assets. Because if they jointly owned anything and that joint owner is still living, the surviving joint owner, in most cases, I'm not going to go into exceptions, but the surviving joint owner is going to get that asset regardless of Xavier's will. So regardless of what a will says. Let's say that Xavier remarried. He owned a home prior to marriage, and then he added his new wife, which is Alexander's stepmom, to title. If Xavier just wants everything, including the home, to go to his son Alexander, Alexander is not going to get the home because the stepmom is the surviving joint owner of the home. She will get the home even if Xavier's will says, I leave everything to Alexander. So joint ownership overrides Xavier's will. Then, if assets are not jointly owned, the next thing I ask, what does the beneficiary designation say? I'm willing to bet that you have beneficiaries designated at this very moment, whether you realize it or not. Life insurance and retirement account are the best example. If the beneficiary is living like Alexander on the life insurance, then Alexander is going to receive the $1 million outright, even as a minor, even if Xavier has a will saying otherwise. This is because beneficiary designations override Xavier's will. So now we're back to probate court. Plus, the probate court doesn't have to choose Zachary as a conservator, even though he's named in Xavier's will. Remember, the will is not legally controlling at this point. The document's only attorney or the online software Xavier used did not tell him about this. He is rolling in his grave. And then if there's any assets left over after we go through joint ownership and beneficiary designations, those assets go into Xavier's probate estate. Xavier's will now controls whatever assets fall into his probate estate, or if he didn't leave a will, state law says what happens to whatever assets fall into the probate estate. So here's surprise number one. Whenever you hear the word estate, it actually doesn't necessarily mean everything that you might own. It only means those things that did not pass to the surviving joint owner or your beneficiary designations. Sometimes people leave no assets to fall into their estate because those first two levels took care of all their assets. And here's surprise number two. A will goes through probate court. Remember how we were at probate court when the life insurance proceeds were paid directly to Alexander? This is the same place we have to go to file a will when someone passes away. This means that even if you have a will, your family still has to go through probate court. Every probate court is public, which is how we know about celebrity estate planning mistakes that make the news. Would you like to see the will of John Lennon, JFK, Babe Ruth, Jackie Kennedy Onassis, Carrie Fisher, Prince? You can, because they all went through the probate process and are all public. And if someone leaves no will, guess where we're at? Still probate court. Everything going through probate requires legal notices to all the parties involved, even if a family member is disinherited. If you've ever had to go through probate for a loved one, this will all sound familiar. As I've worked with many families in the past, I've found that there's this assumption that a will solves every estate planning problem. While it's absolutely critical you have one, it definitely is not the only piece of estate planning you need. So now you're wondering, what do I do if I don't want my loved ones to go to court? So here's the next idea, number three. Xavier gets a trust instead. And in his trust, he says, I leave everything to my son Alexander. If he's 21, I put Zachary in charge. You'll notice that this is the exact same thing he said in his will, but how does it work now? First of all, let's address the elephant in the room. What is a trust anyways? The type of trust we're talking about is a revocable living trust. There's all sorts of types of trusts out there, a lot of which serve a lot of different purposes, but the one we're talking about today is how to avoid probate court. In other words, who can say who gets what under what circumstances and make that happen, but not go through probate court. The revocable living trust is a will substitute, and it's like a will, but doesn't go through probate court, and that's why we call it a will substitute. So here are those three buckets again in the context of a trust. We will go through the joint ownership and beneficiary designations, and we have specific steps we take for each of your assets. We don't stop working for you just because you signed your trust. We need to then take the steps to fund or put into your trust each asset one by one. So first, for some of your assets, we will update the title from your name to the name of your trust. Second, for the other assets, we will update the beneficiary designation from naming, say, your minor child, like Alexander, to naming your trust as the beneficiary. And third, there is no probate estate anymore. Everything you own is in the name of your trust, and your trust itself is a private document that says who gets what under what circumstances. So there is no probate court because a trust is private, making it a lot easier and more efficient for your loved ones to handle everything. Now, I will clarify and say that whether you have a will or trust, if you've got a disgruntled heir who's just bent on causing issues for your family, then it is going to make things more difficult either way, whether you have a trust or not. Although there are more steps to take to challenge a trust over wills, so a trust does at least discourage the not so serious disgruntled heir from doing anything other than maybe just complaining. So I want you to think of a trust and funding your trust like toys in this little red wagon. When you were a kid, you loved putting toys in your little red wagon and pulling it around. And if your sibling, want to grab out your toys from your wagon, there's probably an immediate conflict or high-pitched voices. The way to avoid conflict and exposure that comes with the toys not being in your red wagon is the same with how a trust works. The probate court is avoided for the things you put inside your red wagon. And the legal phrase for this is called trust funding. So as long as your assets are funded in your trust, meaning all of your toys are in the red wagon, then there is no probate court to get these assets passed to your loved one. So let's look at this scenario here. All of the toys are outside the wagon. Here's what happened. You signed your trust, whether it was an attorney's office or something you bought online. Your trust legally exists. You signed it, great, but your trust is the empty wagon. It is not avoiding probate in this context. It is inviting conflict. Would you send your child to the first day of school with a backpack with nothing in it? Well, of course not. What good would an empty backpack do? So you see, we've got this disconnect. We've got a trust. We've got assets outside of the trust. This is not working. This is not going to avoid probate. This is a major danger with do-it-yourself planning or working with a documents-only attorney. Now, this is a much better scenario we have here. We have the assets inside the little red wagon. And to bring back Xavier, he has the life insurance and he gets a trust. And he doesn't just leave it at that. He then updates the beneficiary designation on his life insurance policy to name not Alexander, his minor child. This is what's causing the problems, but to name the trust instead. Remember, we don't want Alex personally to be named as a beneficiary because we don't want the assets to go through probate court, and we don't want Alexander to inherit the $1 million outright on his 18th birthday. So Xavier names the trust as a beneficiary of his life insurance proceeds. This means when Xavier jumps out of that plane and doesn't make it, the life insurance proceed check is literally written to the Xavier family trust, not to Alexander personally. Then the trustee of Xavier's trust, his brother Zachary, deposits a check into the checking account in the name of the trust, and Zachary is immediately in charge of the fund for Alexander's benefit. Plus, Zachary doesn't personally own the $1 million, so even though he is managing it, the money is safe from lawsuits, creditors, and his ex-spouse. No probate court was necessary to make this all happen. There was no court, no conflict, no delay. This is the power of a trust. So here's lesson number one. A review of all your assets is a critical part of estate planning conversation. A document alone is not going to protect you. Okay, that is everything that transpired in sad day number one. I promise the lessons will not all be this long moving forward, but I wanted to cover the biggest questions first. That's a will versus a trust. So thanks for hanging in there. Again, if you have any questions, make sure you jot them down, and you can always email them to me or set up a call afterwards. So now we are moving on to sad day number two. It is a fun ski weekend for the Bliss family, or at least it starts out that way. So the whole Bliss family is having a great time skiing. They're up in Lake Tahoe for a long holiday weekend. They brought their friend Dina with them. Dina's a longtime family friend. Dina doesn't have kids of her own, but she loves Alexander, Benjamin, and Caroline like they're her own children. Starts out as a really fun 3-day weekend on the mountain, beautiful weather to start, but unfortunately, a fog descends over the mountain quickly. Mark and Molly, who are going downhill very, very fast, they lose sight of each other because of the fog. And before you know it, Mark and Molly collide into each other. And now we've got a skiing gone bad scenario. It's a total yard sale. We've got skis and poles everywhere. And where are the kids? They're in ski school. So Mark and Molly are parents of minor children. What happens in an emergency situation with minor children whose parents are injured or missing? Well, ski patrol tends to Mark and Molly, and first responders are helping out. A first responder sees a picture of the beautiful Bliss family in Mark's wallet, and now the first responder knows he needs to check on the children to make sure they're safe. The first responders decide to send Mark and Molly back to Sacramento on a flight for life. Dina gets the children from ski school and plans to get them back home and stay with them as long as necessary. Dina calls Molly's sister Mindy in Texas to let her know what's going on. So Mindy hops on a plane to California with her sister to see her sister Molly and her nieces and nephews. How long will it take Mindy to arrive? Can she get to the next flight out that day, or does she have to wait and get the flight the next morning? I guess Dina will have to stay with the children in the meantime. What you're going to learn may surprise you. It turns out Dina can't stay with the children. Only blood relatives can be the default temporary guardian when minor children are involved and the parents don't have legal documents in place otherwise. This means Dina is disqualified. She's just a friend. This is obviously a huge problem. The kids know and trust Dina, and they are safe with her. If Mark and Molly could communicate, they would say, please keep our children with Dina. We completely and totally trust her. But they can't communicate, and so now we're stuck in no man's land wondering how long it will take for Mindy to arrive. Now, if you're a parent of minors like I am, this is the scariest question of all, because what is happening, with our children is very scary for them. And my children won't know what's going on, and they won't understand who the strangers are. So I want to make sure that they are going to be in the care of someone I totally trust, who I know will love them. Let's do something better for the Bliss family. Mark and Mindy put short-term guardian emergency plan in place to name Dina as a short-term guardian for their kids. Side note, when I'm saying guardianship, you might be thinking, who would raise my children if I can't? And that's absolutely critical, and we'll talk about that, but we call that long-term guardianship, and that's not what we're talking about just yet. Mark and Molly sign a legal document that says, I appoint the following people to be short-term guardians of my children. This is really bridging the time when an emergency or tragedy may happen and how long it takes for those relatives or long-term guardians can get there. I know many of my families have, don't have family members close by, or they may be in another state, across the country, or even in another country. So this is very important. Now on the list can be whoever Mark and Molly choose, blood relatives or not. And they make sure to have local people on that list, and the local individuals are the first to be contacted because they are the closest in proximity to the children and can respond the quickest. And I want to emphasize that your plan will not work unless you share these documents with others. If Mark and Mindy signed the documents, filed it away, and never told anyone that it would be important to share copies, then their plan is not going to work, because no one knows that their plan exists or where to find it if needed. In emergency scenarios, copies of legal documents work just as well as originals. So Dina could pull up the short-term legal document on her phone and show it to the first responder, a police officer, a preschool, anyone who asks. Mark and Molly have a plan. It's personalized and tailored specifically to them and their children, and it's actually going to work when they need it. And if you have pets, the pound isn't a foregone conclusion for them. So know that you can protect your pets too, with a plan in place to make sure that they're cared for in the case of an emergency, or if you pass away. So lesson number 2, guardianship is equally about what happens in an emergency as it is who raises your children in the long term if you can't. So now we're at sad day number 3. Molly's injuries linger. Mark recovers, but Molly is still unconscious and suffering from her injuries. Mark is making Molly's medical decisions for now, despite the emotional burden of the whole experience. Mindy has just landed, and she immediately gets on the phone to the hospital. She wants to know what is going on with Molly, but she hits a big red stop sign called HIPAA. The doctors can't talk to anyone about Molly's medical condition without Molly giving explicit permission in writing. So Mindy is frazzled. She's upset, she's yelling at the doctor, but the doctor says, I'm sorry, there's a medical privacy law called HIPAA that says I can't talk to you. Mindy slams down the phone in complete frustration. Mark has been making medical decisions for Molly before Mindy arrived. But now that Mindy is there, they legally get to make decisions together. So you might be thinking, but why? Mark is married to Molly. He should have the exclusive right to make Molly's decisions. Big surprise, no, he doesn't. The law says any interested person or persons can make medical decisions for someone who's incapacitated when there's no estate plan. This means Mindy and Mark are now on equal playing fields when it comes to making medical decisions for Molly. And you may think this sounds, crazy, and Mark sure does. The law doesn't presume that your spouse has your best interest at heart or that you would personally want him or her to make your decisions. It's just any interested person or person who can make those decisions. And to the extent that there's an impasse, which you can imagine there might be, doctors will tell the interested people it's not our call as doctors to decide who to listen to as the final say-so. So you have to duke it out in front of a probate judge. So now we are back in probate court. But before we get there, Mark is trying to keep up with the medical bills as they pile up. And he's going to learn the hard way that his hands are tied as he tries to pay bills out of Molly's account. Remember, Molly has a saving account in her own name. She had some money in there prior to their marriage, and then when she inherited money from her parents, that's where she put the money. So Mark is not the account owner. They never got around to adding his name to the account. Mark goes into the bank thinking, I'll access the account and pay Molly's bills for her. But when he arrives at the bank, he hits a brick wall. The banker tells him he can't access Molly's account because he's not the account owner. But we're married. Same as with medical decisions, it doesn't matter. This may sound crazy, but Mark is having to go to probate court to both prove he is capable of making Molly's medical decisions himself and that he is a responsible person to handle her finances. Who is the judge going to choose, Mark or Mindy? Because Mindy is just as interested in Molly's medical financial affairs. When it comes to the finances, Molly's thinking, this is the inheritance from my parents, and I don't want Mark to make bad decisions with it. And she's making this very clear to the judge. And Mark is really annoyed because he's thinking, of course I'm trustworthy, and of course I can have Molly's best interest in mind. We're married. Why can't I just access this account? This is such a big hassle. But we're at probate court anyways because that's what the law says what you have to do when someone's name is not on an account, even if they're married, or when someone doesn't specify in advance who makes their medical decisions for them. So this is a nightmare scenario for the Bliss family. Let's do something better for them. So with Molly's medical power of attorney that she's now putting in place, Mark is solely making Molly's medical decisions, even if Mindy is there in person. Now, Mindy, of course, can be very opinionated and be as loud as she wants about disagreeing with Mark, but at the end of the day, legally, Mark has the final say-so, and we don't have to go to probate court or ask a probate judge for permission about that. Under Molly's HIPAA release, Mindy can now call the doctors and find out what's going on. Mindy is named on the HIPAA release, even though she's not Molly's medical power of attorney to make the decisions. All the HIPAA release really means is open communication. Most importantly, Mindy has a copy of the HIPAA release that she provides the doctor upon request. Remember how important copies are. With the financial power of attorney Molly signed as part of her estate plan, she had named Mark as the sole decision maker regarding her finances. This means when Mark walks into the bank, he can bring the financial power of attorney with him and he can get access to the account to pay Molly's medical bills. This is a huge time saver because instead of having to go to probate court, Mark can immediately take this document and act under it for Molly's benefit. This is saving him a ton of hassle, time, heartache, and also money. So here's lesson number 3. The only person other than you that can make your decisions is a probate court. So don't let this happen. Take control. So I invite you to think back and remember why you're here. Who were the individuals that needed your protection? For me, it was my children and my loved ones. And I know that you have loved ones too that you want to protect. So I want to go over what the traditional experience versus the experience that you will experience with us at timeless estate planning. I want to go through that and explain that to you. So the traditional experience in working with a traditional attorney. Now, if you've worked with an attorney, you can identify this, that it's usually hourly billing model. You really don't know how much it's going to cost at the end of the day. It could, a 1-minute call or email can result in a bill at their minimum increment of, just a tenth of an hour or a quarter of an hour, and then your 1-minute call is going to result in essentially being billed for 15 minutes no matter what. So much also about the traditional practice of law is that it's a knee-jerk response to problems. Typically, with lawyers, a problem falls in your lap, you're disputing with another party, you're reacting to that problem, and the attorney gives you very limited options on how to react. When you would have had more options trying to plan in advance to avoid that problem in the first place. Ultimately, with a traditional experience, you are just a transaction, a number. Your matter starts, your matter ends, and then you don't have any ongoing guidance on how to avoid legal problems in the future. So I have flipped the traditional experience on its head. Everything I do is a flat fee agreed to in advance. Very transparent, and you don't have to worry about every little call and email because I don't keep track of our time. You may have a million questions about your plan, and I promise I have had clients who do. And we are here to answer your questions and ultimately help you make sure your plan is exactly how you want it. Plus, I love the interaction with my clients on the estate planning level because it's very proactive. You're planning ahead of time to avoid problems and not responding to negative situations. It's all about deciding ahead of time that you want to avoid a reactive scenario later for your family. And I do really value our ongoing relationships. I want to stay in touch with you over time because I know your estate plan is not a do it once and forget it thing. Your life is going to change. The law is going to change. Certainly your assets are going to change over time. And I want your plan to be current and reflective of whatever's going on in your life at any time. So I will help you update your estate plan as your life changes. So here's my promise to you. Your estate plan leaves no stone unturned and will give you the peace of mind your loved ones and your assets are kept out of court and conflict. So, I know many of you are thinking, how can I do right by my family? How can I make sure that my assets stay out of court and conflict and that my loved ones and my children are always cared for by the people that, I choose and I trust? So I want to walk you through my comprehensive 3-meeting process putting an estate plan in place. And this process starts with the initial meeting. It's called a family wealth planning session where we sit down and go over, one-on-one. It's really a strategy session, what your assets look like. This can also be done, virtually as well. In advance of your estate planning session, you will complete your online family wealth assessment, which is an easy and secure way to provide key information about you, your family, your assets, and your values. Really important information that I will review in advance of our meeting together. Then at that planning session, we're going to hit the ground running. You'll ask questions, I'll ask you questions. You're going to choose your desired estate plan. And then we'll start designing your plan together that day. I'll go over the engagement agreement to indicate which estate plan you choose and the flat fee. You'll sign it and make a payment at that meeting. And then after that, about 4 weeks later is your signing ceremony. This is when your plan is legally in place. This is a big day. You can actually toast with champagne at this day because everything that you have expressed as your wishes and desires in your legal documents is going to be reflected and in effect at that time. So at your signing meeting, we sign all the documents, and a few weeks after that, we actually come back and meet for a final meeting. And the final meeting is very important because we're making sure that all of your assets are directed to your trust. Remember that red wagon? We are making sure that it is filled at that time. So this is about an 8-week process from start to finish, and we make it as easy as possible. Ultimately, the most important aspect of your plan is what you create. You are creating a personalized plan for your loved ones. You are capturing your family wealth in a way where your loved ones will actually know and understand your insights, your values, your stories, and experiences. And ultimately, you are creating peace of mind. I also offer at that final meeting an opportunity for you to, what I call legacy planning, but it's an opportunity for you to share your priceless story, your values and your intentions for how the guardians will raise your children, or if you have grown children or don't have children, really passing on to the people you love most what's most important for you, because we say they're not going to put your trust by their bedside. So this is what you're taking home as well. Not just the legacy, but also the peace of mind with your estate plan. So thank you so much for giving me the opportunity to educate you today. And I mentioned earlier there was going to be a bonus, so congratulations for sticking with me. Here is your golden ticket worth $1,000 value. Now, as long as you do your homework in advance, you're going to receive $750 off the family wealth planning session. If you already have a plan in place, we will also review that plan, and that's actually worth $950. So that value goes up a little bit, but you'll also receive that as well. Now, you may be thinking, well, how much is this going to cost me moving forward? That's a very, very good question. And typically, an estate plan ranges, I have plans actually that start at $1,500 and plans that go, past $8,000, but the typical estate plan is between $4,000 and $6,000. But remember that initial consultation is going to be complimentary as long as you do your homework in advance. And also I want to mention, you'll see the booking link right there. So I encourage you to take advantage of the golden ticket by clicking on that link, and it'll take you right to where you can book that family wealth planning session today. I'm booking usually 4 to 6 weeks out. So if there's specific times or days that you need, I encourage you to look into that sooner, rather than later. So if you have any questions, please visit me at my website. And that's timelessestateplanning.com. And there's also the scheduling link there, or you can email me any questions that have come up today at laura@timelessestateplanning.com. Also, the phone number to reach me at is 650-787-4142. Thank you so much for joining us here today, and I hope to get to meet with you soon.